onto the committee meeting and declare meeting open to the public. I just advise members that the committee meeting is broadcast throughout Parliament buildings and online. And just remind everyone to switch off their electronic devices, particularly as people come to the table. There are 2 oral evidence sessions today which will be recorded by Hansard and published accordingly. I have received apologies from Paul Given as the chair. Any other apologies? On the item number 2 on the agenda is draft minutes of the 6th of March. Advise members that the draft minutes of the meeting held on the 6th of March are on pages 5 to 10 of the meeting folder. Can I ask members if they're content that the minutes are true reflections of that meeting? Therefore, they'll be signed accordingly. In terms of matters arising, as we know, the committee last week asked for the attendance of the Permanent Secretary to discuss the administrative scheme for On the Run. So I can advise members that the Permanent Secretary has agreed to attend the meeting on the Tuesday, the 25th of April at 12:45 p.m. and we will hold it in the Senate building because that's the only room available at that time on that date. Members have also been sent to the Minister of Justice, the Director of Public Prosecutions, Teresa Villiers and Dominic Grieve. We haven't received anything back as of yet from any of the others. I think maybe the Minister has been in contact, but we haven't had any issues in that. Lord Morrow has written to the committee indicating that he's received a request from the Minister of Finance and Personnel to include a new offence of forced marriage in the Human Trafficking and Exploitation, the Private Members Bill, which we're obviously scrutinising at present. Lord Morrow is content for this part of the bill and has written to the Minister of Justice and the Minister of Health, Social Service and Public Safety accordingly, and a copy of his correspondence are on pages 3 and 4 of the table pack. Can I seek agreement of the members to write to the Department of Finance and Personnel to request a briefing paper on the background to and rationale for the new offence and the wording of the draft clause if it is now available, and also to ensure that the Committee for Finance and Personnel also receive the same information? Okay.
Mr. Chairman, if we're dealing with matters arising, I have alerted you to an issue that I wish to raise.
I've agreed that we will bring Chairman's business forward, and at that stage I'll allow you in. Is that okay?
That's fine, yep.
Okay. Item number 3 is evidence by the Attorney General. The Attorney General agreed in his session and he's provided a written summary of his main points in relation to the Human Trafficking Bill. He has also written outlining a further draft suggestion in relation to Clause 6, and both those letters can be found on pages 5 to 12 of today's table pack. Everybody okay with that? With the agreement of members, I'm going to bring forward Chairman's business because John Wells already outlined he has brought a matter to our attention in relation to Desert Creek, so I'll just allow John Wells in.
Mr. Chairman, members, as members will be aware, last night UTV carried a story that the contractor for the Desert Creek Police College is pulling out. Now that hasn't been officially announced, but it's very clear that that company is no longer interested in the contract. And my understanding is that others who tendered may not be interested either. The construction market has picked up considerably since the tender process started, and many companies are finding it very difficult to meet the prices that they've tendered. Now, the difficulty of this is if that happens, the whole future of this particular very important contract is in doubt. They may well have to start the entire process again. We have had numerous problems with this contract. As you remember, that the lowest tender price was £30 million more than the quantity surveyors price for the entire project. It has been delayed inordinately. There are 2,000 construction jobs which were dependent upon this project, particularly in Mid-Ulster, where subcontractors were extremely keen to take up this work. And I'm very concerned that yet again there could be a major delay in this much needed project. Could I also say, wearing my DHS SPS hat, we as a department have a stake in this for the new police college. It will mean that police officers and fire officers will continue to be trained in what could only be described as substandard conditions. And I'm suggesting that, first of all, that we write to the department asking for an urgent update on what is going on with the Department of Justice, and that we also slot in under the Forward Work Programme an opportunity to quiz officials on what's happening here, because we need certainty for this college and we need certainty as far as jobs are concerned.
Okay, I don't think there'll be any issue with that. Any other member want to comment? So we'll ask for, sorry.
No, Chair, I was just going to say, it just has come as a bit of a shock to us, because every time that the officials were in front of us, or the police service or health officials, you know, they were always very, very positive that it would definitely go ahead. It's came as a bolt out of the blue, so I think the sooner we can get that briefing, Chair, would be much appreciated.
Okay. Cindy?
This was raised at the Edit Committee this morning by the Chair, Patsy McClone, and I think the idea would be maybe to work closely with Justice in relation to which way we proceed, and I would take it now that they'll be writing to this committee. I'm not sure, but we could tie in Patsy. I think he's coming along, but maybe he could tell us.
Okay, thank you. Would it be possible to try and get them here for next week? Would we have Yeah. Well, I think what we suggest is we ask for an immediate written briefing and ask officials if they could, that they would come next week to brief us, even though that might sort of add to the length of the meeting. But I think the point that Tom Elliott's made is a proper one, so I think we'll proceed in that manner if that's an agreement with everyone.
Agreed.
Okay. Item number 4 is the legal aid and Coroner's Court Bill, and we have officials from the department here to debrief us today. We have Mark McGuckin, the Deputy Director of Public Legal Services Division, and Carol Graham, the Bill Manager of the Department of Justice. And as I've said in the opening remarks, this is a recorded session by Hansard, and it will be published on the committee webpage accordingly. So Mark's been here a number of occasions, so you just know the format. If you just do your opening remarks, then the members then will ask you a few questions.
Thank you very much, Mr Deputy Chairman, for the opportunity to present to the committee today and for your introduction. I'll keep my comments fairly brief, as the detail is in the bill itself and in the explanatory and financial memorandum. The committee may be aware that the Justice Minister sought the Executive's agreement for the introduction of this Coroner's Court, Legal Aid and Coroner's Courts Bill. Unfortunately, the paper hasn't made it onto the Executive agenda yet, and earlier this week the Minister has written seeking to proceed on the urgent procedure, and we haven't had a response to that yet, so we await the outcome. So in the meantime, this briefing is being presented on that basis. The main purpose of the bill is to dissolve the Northern Ireland Legal Services Commission and transfer its functions and staff to an executive agency, which is to be established within the Department of Justice. It will also set in statute a number of safeguards to protect the independence of the individual decisions on the grant of civil legal aid. There are several key safeguards in the bill. The first is the designation of a civil servant as a Director of Legal Aid Casework, who will be responsible for individual decisions in the award of public funding in civil cases. In taking these decisions, the Director will act independently of the Department and the Minister. The Department and the Minister may issue guidance and directions on how the Director carries out his functions, and any guidance and directions must be published. However, the bill expressly provides that the Department and the Minister are prohibited from issuing guidance or direction in respect of individual decisions. The bill imposes a duty on the Department to ensure that the Director acts independently of the Department when applying any general guidance or direction to an individual case. Secondly, the bill contains a regulation-making power to enable the appointment of a robust and independent appeals panel to hear appeals against decisions taken by the Director. This will help to ensure that there is an opportunity to challenge the decisions of the Director to refuse to award funding or indeed further funding in an individual case. The regulations must require an appeal panel to provide written reasons for its decision on appeal. We will be supporting this with robust administrative procedures to ensure that a reasoned explanation is given for the refusal to award funding in the first place. The bill also makes provision for the transfer of staff from the Commission to the employment of the Northern Ireland Civil Service. The main statutory provisions governing legal aid are the Legal Aid Advice and Assistance Northern Ireland Order 1981, the 81 Order, and the Access to Justice Northern Ireland Order 2003. The 2003 Order will ultimately replace the 1981 Order, but in large parts it remains uncommenced. This has been a complicating factor in bringing forward this bill, as it is necessary to make amendments to both orders to reflect the transfer of responsibilities away from the Commission to either the Department or the Director of Legal Aid Casework. These are reflected in some of the lengthy schedules in the bill. The bill therefore makes changes to both orders to reflect the transfer of responsibilities, but also to support the wider legal aid reform programme. I'd like at this point, Mr Deputy Chairman, to make it very clear that the amendments to the existing legislation do not have any impact whatsoever on the parameters of those who are eligible for legal aid. In order to support the legal aid reform programme, the provisions in Article 10 to 14 and 17 to 20 of the 2003 Order regarding civil legal services will be commenced on the same date that the Commission is dissolved and the agency created. Articles 15 and 16 relate to the funding code, and we do not propose to proceed with the funding code, which was originally intended to set out the criteria for determining whether civil legal services should be provided in a specific case and what service was appropriate. Following extensive work and research and taking on board experience elsewhere, we have concluded that the funding code is an overcomplicated approach which would not best serve the needs of individual legal aid clients. Consequently, the existing arrangements for the merits test remain. The benefit of commencing civil legal services under the 2003 Order is that this legislation provides greater flexibility regarding the people eligible to receive public funding in civil cases and how that funding is delivered than is currently provided in the 81 Order. For example, it provides for regulations that may prescribe that certain proceedings may be funded without reference to an individual's financial resources, or regulations could delegate decision-making on financial eligibility to a solicitor or other provider. It helps to regularise issues such as for non-court solutions, such as mediation or telephone advice, or to enable better use of the private or voluntary sector to provide services, for example through the Law Centre or the Housing Rights Service, which are currently only enabled by the way of authorisations. All of these provisions already exist in the 2003 Order, but have not yet been commenced. In order for civil legal services to be implemented, a suite of subordinate legislation will be required. This subordinate legislation will be subject to further scrutiny by the Assembly, including the Justice Committee. Some of the legislation will involve the Assembly's affirmative resolution procedure. Pending commencement of the provisions in Article 21 to 31 of the 2003 Order regarding criminal defence services, representation in criminal cases will continue to be provided under Part 3 of the 1981 Order. Accordingly, as an interim measure, the bill will also amend Part 3 of the 81 Order to replicate some of the provisions in the 2003 Order regarding the assignment of solicitors and counsel, to provide for a registration scheme and place restriction on the disclosure of information in relation to legal aid applications. The bill will also make the Lord Chief Justice President of the Coroner's Courts and require him to appoint a presiding coroner, thus formalising his responsibilities in relation to coroners and the Coroner's Courts, in line with the existing arrangements for the other judiciary and courts in Northern Ireland. Further detail on the contents of the bill is set out in the paper and in the explanatory and financial memorandum. And I'm happy to address any questions that the committee might have at this stage on the content of the bill.
Okay, thank you very much for that, Mark. Just in relation to the urgent procedure, when do you expect that to be, finalised so it can be advanced?
That's out of our hands. It's the Minister has written to the First and Deputy First Minister, whom you know are out of the country at the moment, and I'm not sure what the arrangements are to process that while that's happening.
It's a narrow enough window. Like we need to be as
It is, and they have
speedy
been.
as possible.
They've been appraised of that.
And in relation to, just an obvious question is that this is one of the recommendations of the review in 2000.
Yes. The coroner's court was, yes.
Yeah. We're only doing it now. Is there any explanation for that?
I think the explanation is that there was an oversight at the time,
Okay.
and since it was identified, this has been effectively the first opportunity to remedy that.
Okay, I'll bring in our members just now. Jim Wells.
I'm hoping that this change, which I'm sure we'll be supporting, is in response to the clear inadequacies in the present structures and the fact that year after year, and monitoring rounds, we have to find money because the Legal Services Commission has gone over budget. But how will these new structures make the disbursement of legal aid more accountable to this Assembly and to the Department of Justice?
I think it is currently accountable, and I'm not sure that these arrangements will make it any more accountable. What we would hope to do is to improve the governance of the arrangements and to improve the process of implementing the reform programme that we're currently undertaking. It'll bring it in closer to the department. It will make the decision-making processes that much easier in terms of driving forward the reforms. It'll cut out some of the governance streams and make that a much simpler process.
But will it enable the department to keep a much tighter watch on budget overruns and to make certain that we don't have this annual, as we've had this year, further requests for more money, very scarce budget allocations, basically be put into the pockets of solicitors and barristers?
There are two aspects to that. First of all is to bring the budget down to bring the spend down within the level of the budget, and some of the other reforms which we've presented to this committee and have progressed are intended to do that. The second element is in terms of forecasting, to ensure that we've got the right forecast to start with and we're not hit in the middle of the year with unexpected consequences. And that has been a major project which was initially being taken forward by the Commission but was brought into the department towards the end of last year. We've gone a long way in developing the methodology for that new forecasting mechanism, and also crucially making the necessary connections and relationships with other parts of the criminal justice system and more wider, so that we're alert at a much earlier stage to any changes which could impact on that forecast.
And will this, as far as staffing concerned, will this be simply a transfer across of staff from the existing body into the new model, or will there be a recruitment of a new team?
This will be a transfer across of the existing staff. The bill makes provision for them to come across under TUPE. So they will transfer across into the new organisation, and there will be an opportunity then to look at the management structure and how that operates as an agency within the department.
But will that aspect of the staff be a new team, or will it simply be a transfer of the senior management across?
It's too early to say precisely what will happen, but there have been a number of changes within the top team in the organisation already. For example, the Director of Corporate Services recently moved on to take up a new opportunity outside of the Legal Services Commission, and we have seconded an experienced civil servant into that position in order to help to manage the process and the change process through. So we're already starting to see, because we're taking the steps towards the creation of the agency, we're already beginning to see the interchange of some new people coming into the organisation from the civil service background and with that experience.
So this is the third major change. It was originally with the Law Society and it was the Legal Services Commission. It's now moved into the new body. But if that doesn't address the fundamental problems of budgets and budget overruns, then the public and indeed the Department of Finance will be extremely disappointed, because that is an issue that has bedeviled this organisation for many, many years.
In of itself, it won't address the issues with forecasting with the budget. It will assist that process, but it has to be tied in with the wider range of reforms which are ongoing to reduce cost in the system as well. It is a demand-led service in terms of legal aid, and you need to continue to respond, and that will be the same in the future.
Just one final question. As I've said to you before, I believe the cost should be brought down to the same as every other part of the United Kingdom, a system which has worked for many years. I do not see now that we're post-Troubles why we should have a situation in Northern Ireland where it costs much more to defend most cases here than it does in the rest of the UK. So I think you need to be more brave, and the opportunity of this new organisation is a chance to deal with that issue like for like. Somebody should be paying any more in Belfast than they are in Birmingham.
We will be continuing to bring forward reforms to the committee and to the Assembly as we progress this work with the bill and with the change in status of the organisation.
Okay. Alban?
Thank you very much, Chair, and thank you very much for your submission today. Just in relation to the Legal Services Commission, how much does that cost a year, roughly, a ballpark figure?
The Commission itself, or the Commission and its staff?
The Commission and its staff.
It's about 7 million a year.
About 7 million a year. And would you hope that you could reduce the that cost downwards?
There will be some efficiencies in this exercise as we go forward. It would be very difficult at this stage to say precisely what those will be. And I know that the Commission are already looking at how they deliver their business model to try and improve its efficiency as well, so that we're reducing the administration. There are a number of measures in place to try and take that forward. For example, the Commission is starting to develop the business case for a new case management system, a new IT-based system, which will bring benefits to the administration within the Commission itself, but also wider benefits to solicitors in the community who are having to interface and interact with the Commission on an ongoing basis. And those sorts of measures should help improve efficiency. We'll continue to do those as when the agency is created, and clearly look for other opportunities as well.
Could I just ask you, thought comes to mind, I mean, can you at this moment in time make an application online?
No.
No, but that's the type of thing
That,
that would hope,
absolutely.
could be done.
Absolutely, and there's a piece of work being done now to see whether we could bring that in advance of the case management system.
That would improve the efficiency, obviously, of the organisation. Now, what you're doing, if this materialises, really is transferring the Commission from I suppose, an arm's length body really into the department. How does that transform the workings of the, leaving aside the whole issue of independence and so forth, how does it transform the workings of the Commission in terms of its efficiency, in terms of its productivity, in terms of doing a better job? Because it's had a very bad press in terms of the Criminal Justice Inspectorate report and so forth. How would you? How is that going to?
There is no single key in relation to improving the efficiency and making it work better. I think creating the agency and bringing it closer to the department allows a number of steps to be taken to look at the efficiency, look at the processes and the practices which operate within the organisation, to look at, they will come on under a common set of terms and conditions of service. So, for example, there's clarity about what that is, and it applies across the broader NICS, and you don't have a small organisation trying to manage all of that itself. It allows you to draw on experience elsewhere, to second people in, to move people in, and to refresh, if you like, the arrangements within the agency, within the organisation, in a way which isn't really possible as an NDPB. So there are a range of factors there which cumulatively will help to support improving the efficiency and effectiveness.
But it doesn't necessarily do that simply by bringing it into.
No, absolutely.
There's a lot of work to be done.
There's a lot of work to be done, and that was one of the reasons, and I just mentioned in response to Mr. Wells' question, that was one of the reasons when the Director of Corporate Services moved on, that we took that opportunity to bring somebody in to the organisation who has change management experience and a change management background to help the organisation prepare itself for the transition to its new status and to bring the staff along. There's a significant programme of work which Carol is also leading on across a whole range of factors which will affect the way that the organisation works and the way that staff see themselves within the organisation.
Just talking about staff, is one of the problems the large turnover in staff? Or is there a large turnover in staff? I understand that there is, but
there hasn't necessarily been a large turnover in staff. There are some staff who have been there for a very long time,
yes,
are very experienced in terms of legal aid, the requirements and so on. And at certain levels there is a turnover, and that has been increasing recently. It's not necessarily one of the problems, and a turnover when we become an agency will give an opportunity just to refit, and that I think is one of the opportunities that you do have.
I won't press you on that point, but just a couple of other points, Chair, if you allow me. In relation to the whole issue of decision making, obviously the department can't make decisions, and the commission in its new form will make decisions, and the director of the commission will be the ultimate person with responsibility for doing that.
Yes.
And he or she will be separate from the minister in doing
Yes.
that in individual applications. At first instance, I assume that the applications are made on paper or online, as may be, and a rejection would then be subject to an appeal. Now, we had some discussion about this in the past. The appeal would be to 3 people, is that correct?
That's correct.
Would those 3 people be made up of lawyers and lay people, or what's the position?
The position in relation to the appeals panel is that we are seeking to recruit a mixed appeals, a mixed group of people from
Yes.
which to draw the appeals panel. Each individual appeal panel will be made up of 3 individuals. The chair, we intend, will always be a lawyer, and that was
Yes.
one of the points which came out in the consultation. In the consultation, we had suggested that it could be a single person,
Yes.
and not necessarily a lawyer. And we responded to the consultation, and instead of going for a single individual, we've gone for 3 people sitting on the panel. The chair will always be a lawyer. And depending on the makeup of the people who apply to take on this role, it could be that most appeal panels would be made up entirely of lawyers. But we would like to try and bring in experience of people who might be involved in family situations and so on, if that's at all possible. And that might be a process that will take some time to work through.
So you're trying to establish some sort of balance
Yes.
between lay members and legal persons?
Absolutely.
But it will be a 3-person.
It'll be a 3-person panel with the chair always being...
Right. One further point of detail in relation to this, Chair. Will the appeal be on paper, or will the appeal be in person? Obviously, the solicitor or barrister making a representation to the panel.
Can I answer that by taking a step back to look at the broader process? The broader process currently is that people will make solicitors on behalf of their clients will make an application for legal aid. That will be considered and either rejected or accepted. If it's rejected, quite often there are some reasons why there's some deficiencies in the way in which the application has been made. What we want, and in the current environment, quite frequently they just go straight to the appeal then. What we want to try and do is to introduce a much more robust system where we start in the initial adjudication of the request, of the application. We give reasons for the refusal, so that if there are deficiencies, they can be addressed and the application resubmitted without having to go to the appeals panel. We would therefore see that the number of appeals going to the appeals panel would be much reduced. Because we've been given reasons then, and will continue to give reasons right up to the point that the appeal is being lodged, it will be for the solicitor involved to address the reasons for the refusal as part of the appeal. And from that perspective, we envisage that most appeals could be heard on the basis of papers.
Right.
But we have made provision, or will make provision within the regulations for the appeals panel to allow an oral hearing where that is considered to be appropriate.
Yes. So you've got a sort of filtering process. Once there's a rejection, there's a sort of filtering process. You look at it, or it's looked at by a panel on paper,
Yep.
and then a decision is made.
Yep.
And in extremis, then there would probably be an oral hearing.
There's a possibility of an oral hearing in appropriate circumstances.
Yeah. One final point, Chair,
Sure.
and thank you for your indulgence. Just in relation to the funding code, I'm not quite certain what that's all about. There is, at the moment, an SL1 coming to the committee in relation to eligibility
Yes.
for criminal and civil legal aid. Is that anything to do with that?
No.
That's a separate process.
Absolutely, yes.
Yes. Okay. So the funding code is a separate procedure.
The funding code,
which you've rejected.
The funding code was a very detailed, an attempt to get a very detailed arrangement for how civil legal aid would be awarded and the merits and so on, and it became overly complex and complicated. The paper which is currently in front of the Committee on Financial Eligibility is about adjusting the existing merits tests, and as ever, those sorts of things would come before the committee for any change.
Thank you very much, Chair.
Okay, thank you. Tom?
Chair, thanks very much for the presentation. Sorry, just quickly explain again how it's been on the books since 2004 and now it's coming forward at a speed of a train.
I'm not in the lead on the policy in relation to that, Mr. Elliott, but my understanding is that a lot of changes were made. I think it's probably 2000 when the review was first published. But there were a lot of changes made at that particular point in time in respect of the judiciary, and this was one aspect which was overlooked. And I'm not actually sure when it came to light, but it was something which the Lord Chief Justice raised fairly recently, and this has been the first opportunity that we've had to address it.
Chair, it would be useful if the committee were to get an explanation as to why. Probably is a perfectly good explanation. It would be useful for us to know.
Okay.
Second question, Chair, is around the staff. And really what we're talking about here is a transfer of staff from the Legal Services Commission over to the new body.
Into the Northern Ireland Civil Service, yes.
Yeah. So it's just moving the deck chairs a little.
I wouldn't necessarily describe it in those terms, no. There are an awful lot of very experienced staff, as I was saying to Mr McGuinness, there are an awful lot of very experienced staff within the Commission. And what we want to try and do is to put them into a slightly different environment within an agency with the governance arrangements around that to enable them and support them to deliver their responsibilities effectively and efficiently.
You did use the term something like, and it mightn't be exactly, Mark, but it was something like there will be opportunities for personnel from a civil service background to go in there. Are there any opportunities for people from the private sector to go into an organisation like that?
Through normal civil service route, into an organisation like an NDPB or
well, particularly into the new agency.
Well, it depends on the nature of the staff and the terms and conditions that you have. There are a number of recruitment exercises which occur at different levels within the civil service currently, which brings people in from the private sector at all levels of the civil service, from the administrative grades right up to the senior civil service competition, which is currently underway, which is bringing people in from outside of the Northern Ireland Civil Service into the organisation.
Chair, sorry.
And so it would be those similar types of opportunities.
Yeah.
Some specialist grades, for example, you would find that accountants would get recruited at various levels within the civil service and go straight into organisations such as an agency at that stage.
Okay. Chair, so it's not just to do with this department, but I often wonder how people who don't have a civil service background can actually get into the system. At least an elected representative can stand for election and either gets elected or not elected. But within the civil service, it quite often seems to be a closed process with no opportunities for people who would have good experience and knowledge of the wider world to actually maybe be of significant assistance to that department, wherever it was. And it's not just, I'm not just referring to this aspect actually, but it's in a wider context. Thank you, Chair.
Thank you. Rosalind?
Thanks for the presentation. Can I just ask, in consultation, what were the main sort of difficulties that would have been expressed with this changeover, if there were any?
I think the main concerns were around the appeal panel.
Appeal panel.
And because, as I was saying to Mr McGuinness, in the original proposals that we consulted on, in terms of the safeguards, we had suggested that the appeals panel could be limited to one person sitting, hearing appeals drawn from within a number of people, and that person wouldn't necessarily always be a lawyer. We got some convincing arguments coming back to us to suggest that the type of decisions which were being taken, it would be appropriate that a lawyer was involved, and that it would assist if there was more than one person sitting on the panel. So we responded to that. The existing panels, I think, it's all lawyers and involved in those, and they sit largely as a panel of 5. So we've brought it down to 3, and with the aim, if at all possible, to get some lay experience onto that panel as well. Essentially, it'll be chaired by a lawyer, so there'll still be a very legal aspect to it.
Okay, and then in terms of staff moving across, are there any issues to do with pensions? Because this is a subject that it comes up frequently. Staff in organisations concerned that when changes happen, that their pension's going to be affected. Are there any implications for pensions?
Oh, there certainly are. I mean, the Legal Service Commission staff are currently part of the NILGOS, the local government pension scheme, effectively. And when they become part of the Northern Ireland Civil Service, they will become eligible to join the Northern Ireland Principal Civil Service Pension Scheme. So they become under the same pension scheme as civil servants. When they're taking, they will be given a choice at the time that they're moving across as to whether or not they retain their existing service within the NILGOS scheme, or they transfer it across to the Principal Civil Service Pension Scheme. And they will be given an awful lot of detailed information that actuaries work out and an information pack in order to help them to make the best decision that meets their particular needs. And I understand that for most people it will be attractive to make the transfer across.
Okay, so nobody will have anything forced upon them?
No, they will. The only change which will happen is that from the point of transfer, from the point that they join the civil service, they will go on to the civil service pension scheme. It's what actually happens and how their past service is treated is where they get the opportunity to take the choices.
Okay then, very good.
Nobody else has indicated. Just a couple of final questions. The sort of timeline for this is to have it enacted for October. Is there a financial benefit for that timeline, or is it just, get this done as quickly as we can?
The way we were looking at it now, it is right tied up in a financial issue in terms of how we fund. There is a cost associated with addressing the pensions issue, and currently we have an arrangement that would allow that to happen within the next financial year. It would be preferable to try and get it done by the 1st of October, yeah.
Okay, but is there a financial benefit, any financial imperative to do it, or is it just that's the best timeline possible?
It's the best timeline that we've got currently.
Just in terms of, in the department's briefing, there was a consultation of the review of the statutory exceptional grant funding scheme.
Yes.
The clerk and the committee, the staff couldn't find any publication for us to use for scrutiny. Is there any particular reason for that?
On the exceptional grant scheme?
Yeah.
There was consultation on that in the course
It
of
was
last year.
Yeah, but
It hasn't come back to you yet. No, there are other pressures have meant that we've set that to the side slightly.
Okay.
And that was to do with that's largely to do with the remuneration scheme.
Yeah.
In respect of that, and we'll be coming to you hopefully around May time with something on that. But it is still on the agenda.
But there's no crossover for this particular scrutiny in this bill?
No, there shouldn't be. In relation to this bill, in relation to the exceptional grant scheme, this bill will move the responsibility for taking those decisions from the minister to the new body, and that was part of the recommendation in the Access to Justice review, which was accepted at a very early stage.
Okay. Mr. Wells says a small point.
It was just a point of information
Go ahead.
arising out of Ms McCorley's question, which was in relation to pensions. Is there any difference? I thought there was some dispute within the Commission in relation to pay rates within the Commission. Is there any difference between the pay rates of the Northern Ireland Civil Service and the Commission currently?
Yes, there certainly is. And we have a business case and approval from the Finance Minister to bring the existing staff in the Legal Services Commission onto the Northern Ireland Civil Service pay scales with effect from the point of devolution. We are currently working through the final stage of that process, which is to present the pay remits to DFP and to the Finance Minister, and we hope to conclude that very, very shortly. We've been working quite hard on that for the last number of weeks. That will bring those staff directly onto line with the NICS pay scales and will help the process of moving us across to an agency as well.
The staff will be happy, I mean.
I would hope so.
Could I just say that I think Mr McGuinness and Mrs McCorley both indicated, and I think Mr McGuinness used the phrase rearranging the deck chairs.
Oh, no, I didn't. No.
Oh, sorry, Mr Elliott, I apologise. It was a good one-liner.
I'm not into cliches.
And I'm sure the impartial reporter was tipped off there was a good one-liner coming, but serious about it, I don't get the impression that there's the degree of urgency that really is required in this organisation. We've already had the very damning report from the auditors who came in and said that this organisation was completely dishevelled. I mean, it just wasn't working at all. It was spending far too much money. The budgets were completely out of line. We're having to rob much-needed services within DOJ to pay for it. And I don't get the impression that this really is an urgent dealing with an organisation which wasn't fit for purpose. All the impression I'm getting is you're simply moving it across, lock, stock and barrel, into a different structure, but you haven't actually tackled the root and branch problems that occurred previously.
I think, as I said in response to your earlier questions, there are a number of factors involved in that, and there are a number of pieces of work going on. The actual spend has to be brought down to meet the budget. And that is work which is, you're well aware, is going on. Within that, we are also working within the Commission to improve their procedures. And as part of that process, and I mentioned the Director of Corporate Services being one post where we've started to make that bringing a different perspective in. We've also got a new IT manager in there. In addition to that, within my division, we've brought some of the experienced staff from the Commission to help us inform our future policy work. So there is an exchange going on there, which is hopefully starting to address the issues, and certainly isn't about moving deck chairs around.
Well, can I say it'll be very uncomfortable if after 3 years this is up and running, we're back to exactly the same problems that have been dealt with legal aid for the last dozen years in this province.
Well, I would be seeking to, over my watch, to avoid that.
Right. Thank you.
Okay, thank you very much for your remark, and Carol, thank you very much.
Good luck.
Need it?
Can I just now ask members whether they're content to support the principles of the bill at second stage, or whether we feel that there's any further information or room for comment at this stage?
Yeah.
We're happy enough to proceed? Okay. Agenda item number 5 is the proposals for handling the committee stage of the Legal Aid and Corners Bill. And can I refer members to pages 14 to 26 of our table pack, which have also been circulated electronically today. The Minister has indicated that he would like this bill to be a priority, and his aim is to have royal assent as soon as possible, and not later than September 2014. He has therefore asked the committee to look favourably at keeping the committee stage of the bill as short as possible to enable consideration stage to take place before the summer recess. The committee has agreed in principle in September 2013 to consider ways of expediting the committee stage of the bill, and proposals to facilitate this have been prepared for consideration. I'm now going to ask Christine to take us through those considerations. Okay.
Thank you, Chairman. As the Chairman has pointed out, the committee did agree to look at ways of shortening the committee stage of this bill. The position really is, if the Executive clears the bill for introduction to the Assembly at the meeting next week on the 20th, then the Department will introduce it on Monday the 31st of March and schedule a second stage for Tuesday the 8th of April. And assuming it passes second stage, the committee stage would then commence on the 9th of April. To enable consideration stage, which is what the Minister has asked for to take place prior to summer recess, committee stage would have to be completed by Friday the 20th of June, and this would provide for a 10-week committee stage for the bill. However, it's worth noting that in that 10 weeks, that will include the 2-week Easter recess period and the week of the European and local government elections. So the likelihood is there's probably only going to be roughly 7 weeks of committee meetings in which to take the bill through. So if the committee is minded to look at that timescale, then to achieve it, the following would be necessary. First of all, we're suggesting that the committee would need to invite written evidence in advance of committee stage by issuing a public media signposting notice and writing to key stakeholders on the 4th of April, which is slightly before second stage. Now, while it's unusual, it has been done in the past where scales are tight, and it can be done, pointing out it's on the assumption that the bill will get through second stage. We're suggesting that you write to a targeted number of key stakeholders, and a list has been provided. What we've done is we've looked at the stakeholders who responded to the Department's consultations on the issues in the bill. They undertook a very wide consultation but only received 17 responses, and given the technical nature of most of the parts of the bill, it's not expected to attract a large amount of interest apart from outside the professional lawyers, etc. So we're suggesting you write to a targeted number of key stakeholders and allow 3 weeks for the receipt of written evidence, which would give you a closing date for written evidence of the 25th of April. Again, we would generally allow 4 weeks, but on this occasion, given that most of the organisations have already responded to the consultation, we're suggesting 3 weeks. And then we're suggesting that the committee holds one evidence event, probably on either the 8th or the 15th of May, to take oral evidence. So rather than spreading the oral evidence out over a number of weeks and meetings, that we do it at one particular date, to make sure that we take it all at the one time. And that's apart from obviously the department's officials who will come up as and when required to provide further information. So a draft media signposting notice to be placed in the 3 main newspapers and on the Assembly website, a draft list of key stakeholders to which it is proposed the committee should write, and a draft letter has been circulated in your papers. Also, just to highlight for members, the Attorney-General for Northern Ireland has written to the committee, and a letter is at Annex E of your papers, asking the committee to consider a potential amendment to the bill relating to his powers under the Coroners Act, Northern Ireland 1959. The amendment, potential wording of which he has provided to you, relates to his powers to direct an inquest where he considers it advisable to do so, and it would confer a power on him to obtain papers such as serious incident report forms and provide a clear statutory basis for disclosure. And he's highlighted in the letter some issues he's had over the past while in relation to that area. So what we're suggesting to members is, given this is a new proposal for an amendment to the bill, that you may wish to request views on it when you're writing out for evidence on the bill, so that when you come to look at it, you will have any views available to you. And as I say, wording in the draft letter has been included to that effect. So that's basically the outline. If you're happy or you want to go with a 10-week committee stage to bring it in to allow consideration stage to take place before summer recess, those are the steps that we're recommending you would need to take to deliver it within that time scale.
Okay, thank you, Christine. Tom?
Chair, thank you, and thanks, Christine, for that summary. What happens if we don't agree with that?
If you don't agree, you can agree whatever time scale you want.
Yeah, but what's the outworkings then of the...
The outworkings would be if committee stage isn't delivered by the 20th of June, further consideration stage couldn't be scheduled before summer recess.
Yeah.
If the committee would sign off the report by the 20th of June, I think it's Friday the 20th of June, but that week you would sign off the report. But it takes 3 or 4 days to print the report, and the report needs to be available for members before the close of amendments on a Thursday. So if you were to deliver it by the 20th of June, we can have the report printed and out the following week, which would allow the consideration stage debate to take place the last week before summer recess.
Yeah, but what if the consideration stage didn't take place before recess? I'm trying to find out what is the outworkings.
It would basically, well, we'll take whatever time the committee decides to take, and the department will then have to push back their consideration stage, so they're not likely to meet their October deadline that they're looking for.
Is the October deadline absolutely critical, though, for the department?
It is.
It
is for Leicester.
Well, I think there was a question asked of officials when they were here, and they were indicating that they're keen to have it in place, or the bill through. I think it's the outworkings of the bill after that, and they appear to be indicating that in relation to the pensions issue, they have money in next year's financial budget to cover that.
I don't want to sound legislator or anything,
No.
Clearly the Attorney-General has put down a significant proposal for an amendment.
Yeah.
We would have to consult on that at the same time, I think. You know, if we're considering it at all, I'm assuming we would have to decide whether we even agree to consider it and then allow it to go for consultation. But I've no difficulty or no wish to hold it up, but I'm just trying to find out if there was some blip along the way, that there was some other significant piece of work came in for the committee that we had to stall it for a week or two.
I think the issue is really when the committee decides what final date. So, for example, we're suggesting at the minute you're looking at 10 weeks, and it'll be the 20th of June. But the motion to extend your committee stage will finish within the 30 days, and we have to put a motion down to extend it. That motion doesn't have to be agreed by the committee and tabled until we come back after Easter recess, which would be after the closing date for written submissions. So what you could do, is, if you wanted, was to agree in principle now for us to go ahead with the steps we're suggesting, and then when we come back after Easter recess, you can decide whether, given the responses you've got on the bill, you still think it's manageable to bring it in, or at that stage you can decide that you want to table a motion for a longer committee stage. It would give you that option. You're not actually today having to say definitively it will definitely be the 20th, and there's no movement on that. So you could have an opportunity when you see what you get in the written submissions and the volume of responses, whether you still think it is doable within that time, or whether, given the issues being raised, you think you need longer.
think that's reasonable,
Okay.
Chair, and just wouldn't like the department holding it back for 4 years and then trying to steamroller us through something, you know?
4 years. You've been generous with 4 years. You know? Well, mindful of Tom's caveat, are members then content that we move forward to complete the committee stage of the legal aid and coroner's bill by the 20th of June? And that's assuming that the bill is actually introduced on the 31st of March. And if so, that the request for written evidence on Friday the 4th of April, before completion of the second stage, that we have a 3-week consultation period with a closing date of Friday the 25th of April, and hold one evidence session for oral evidence from key stakeholders. Okay, so if members are content with the proposal, we just ask now. Sorry.
No, I'm just agreeing, that's all.
Okay.
It might seem unusual, but
How dare you?
So if members are
Typecast.
content with the proposal, we'll just ask that we formally agree that the draft provisional timetable for the committee stage of the bill, the draft media signposting notice, the draft letter which includes a request for views on the Attorney General's proposal, and the draft list of key stakeholders. Okay. Okay. Agenda item number 6 is reducing avoidable delay in the criminal justice system and improving services for victims and witnesses. And this progress report, so can I invite the officials to the table? And can just advise members that Include Youth has provided a copy of its written submission to the department in relation to the consultation on the proposal for the introduction of statutory time limits in the youth courts. And that's on page 269 to 283 of our meeting folder. And NACRO and Victim Support have provided information, a copy of their joint submission on the same issue, and that can be found on pages 30 to 40 of our table pack. Can I welcome to the table Maura Campbell, Veronica Holland, Jane Moore and Chris Matthews. And just for members' clarification, we're going to take this in 2 separate, we're going to proceed with the unavoidable delay and then improving witnesses service. So the same format, opening remarks and then questions from the members. So I take it, Maura, you're leading.
Yes.
Okay,
yes,
so over to you. Thank you.
Thanks very much, Chair. And as you say, happy to do it as a game of two halves, so to speak. This is the latest in our series of regular reports on speeding up justice, and we're also taking the opportunity to give us our first report on the delivery of the new victim and witness strategy. Starting with speeding up justice, when we gave our last report back in July, I said at that time that we weren't expected to see a dramatic change in performance over the following period, and that's proved to be the case. As you'll have seen from the briefing pack, performance in the Crown Court and for both adult and youth charge cases has stayed fairly level over the last period. There has been some improvement in both adult and youth summons cases, but these are still taking a lot longer than charge, so they're longer than we would like them to be. We're now generating new performance reports using data taken from the Causeway system, and this meets a recommendation by Criminal Justice Inspection. In developing the Causeway reports, we've taken the opportunity to add in some new measures to give us a more comprehensive picture of how the system's performing, which includes end-to-end measurement from the start of proceedings to the completion of a case. And we're also now measuring performance in percentage times. The principal measurement continues to be average days, so that we can continue to make broad comparisons with previous reports. But we have changed the way in which we're measuring the time taken at key stages so as to give greater clarity about how individual organisations are performing, which should give us a better insight into where some of the blockages may be. We've provided a bit more detail on the change in reporting in the paper at Annex E. Since our previous update, we've been conducting a consultation on the equality impact assessment of youth engagement clinics, and we're due to come back in on the 3rd of April to brief you on the outcome of consultation and the proposed way forward. We received 6 replies which were supportive of the concept of clinics. And while the responses highlighted some areas of concern, these were essentially the same issues we had identified ourselves through both the EQIA process and the evaluation of the clinics. And all of those issues are in the process of being addressed, but as I mentioned, we'll be coming back shortly to brief you in more detail on this. We've also been consulting on our proposals for statutory time limits in the Youth Court, and that consultation had been due to close on the 25th of February, but has been extended at the request of some organisations who asked for some extra time to put in their response. And although that consultation is still underway, it's clear from the responses received so far that some organisations continue to have concerns about the proposed start point for the time limit, though there has been support across the board pretty much for the idea of having statutory time limits. We'll want to take time to consider the responses very carefully and come back to you with proposals on the way forward. And in the interim, we might seek to have some further discussion with stakeholders about what more we might be able to do at the front end of the process, because that seems to us to be what is the real root of the concerns that have been expressed. For instance, with the agreement of the Criminal Justice Board, we've recently been looking at whether there's scope to increase the use of charge in youth cases, where that would be an appropriate and proportionate response. For instance, for prolific offenders, for young people already in custody, or those who failed to respond to a summons in the past. We're also looking at further ways to cut down the length of time taken to serve the summons, because that is what has been taking up the bulk of the time in the summons cases. This is still at a pretty early stage, but today would be a good opportunity if the committee have any views they'd like to share with us as we decide how we might take that forward. The papers in Speeding Up Justice also give an overview of the draft Justice Bill, which we're hoping to be in a position to introduce soon, and actually the timetable you're discussing for the Legal Aid and Corners Court Bill, if that's followed, would be helpful to us in allowing us to make progress ahead of the recess potentially in that bill as well. And it also includes the work that's underway to reduce turnaround times for forensics. So just in summary, the briefing pack for today on Speeding Up Justice covers a very wide range of activity, and we'd be happy to pause now to answer any questions or provide detail on any of the issues that are covered.
Okay, thank you very much. Can I just sort of kick it off by I mean, obviously, the whole intent and the whole purpose of all this is they do away with unavoidable delay or they tackle it. In terms of setting out, you know, the targets which the department has set itself, how far do you think you've come, and what's still the main obstacles in achieving what should be realised?
I think we've made fairly steady progress since 2006, which was really when we started measuring performance against a set of performance standards that were developed by the Criminal Justice Board. So it was the department in collaboration with the principal agencies. And I would say, although we've been at times sort of failing to sort of match up to those standards, even if we met those, I think there's still a chunk of time that we'd want to be trying to take out of the system if we can, and particularly in relation to youth cases where we've had a particular focus over the last year or two. Any opportunity we can take to get the time down still further, we'll want to take that. I think what we've found is that we've probably exhausted the scope to make much more progress under the recommendations that we'd had previously from Criminal Justice Inspection. I think they've taken us part of the way, and really what we need to do now is get into the more substantive reforms of the system, some of which require legislation, which is why we're keen to bring forward the Justice Bill. That will tackle issues like committal, and it'll help us with encouraging earlier guilty pleas, making the summons process more streamlined and so forth. Statutory case management should help us as well. But I think there's more we can do as well in procedural terms to try to streamline processes wherever possible. And we took the opportunity during the consultation on statutory time limits to test out some proposals on how far we could go with that, and we'll be analysing the responses to that as part of the STL consultation.
And just in terms of the causeway system, has that highlighted or thrown up, you know, a particular type of case or a particular location that isn't as fast as ours? Because, you know, and I accept this is a bit sort of anecdotal, but you know, you get the impression sometimes a particular judge in a particular area, you know, doesn't allow delay to happen or in front of them, and that, you know, are you picking that up from the database, or you still look at it from a very general point of view?
The Causeway does allow us to break the data up in different ways, which is really helpful. I don't think our analysis to date has highlighted any particular geographic differences or differences in... obviously, more serious offences will tend to take longer. That's fair enough.
Yeah, I think the reports are still at fairly high level, and they wouldn't drill into the level of detail you're talking about, you know, in terms of individual courts. We'll look at it in terms of regional performance, and that's generally across the piece. We're looking at it in terms of is one region outperforming another, and what are the reasons behind that. But generally, areas are quite consistent in terms of level of performance. The blockages that we're already aware of in terms of time taken to serve summons, for example, we're already in the frame before we move to the Causeway system.
So they would be consistent right across. You know, there wouldn't be even like where's say a particular region. You know, they're sort of the PSNI may be better presenting statements to the PPS, and that speeds it up. You're not seeing any regional disparity. It's pretty consistent.
Nothing particularly stark.
Okay.
Yeah, I think it's the same issues pretty much across the board, and it's the same interventions that are going to be required.
Okay, thank you. Sean Lynch.
Thank you, Chair, and thanks for the presentation. At the outset, tomorrow, you said that from the report in July there had been no big change. What are the key problems that hasn't brought about any major change?
I think we have seen a fair bit of change in charge cases. We've made, pretty good inroads in those cases. The real problem, as we would say it, would be in summons cases. And as I mentioned earlier, the big chunk of time that tends to be taken up with the service of summons, which is why we're quite keen to see if there's more we can do with that. There's some provisions in the Justice Bill that will help with that, but we're looking to see if we can go further again. We were able, under the youth engagement clinic process, to develop something that we refer to as immediate summons, so that if the young person didn't take up the offer of a diversion, the summons could be served on them on the day, rather than sending it out and waiting 4 or 5 weeks for that to be responded to, or maybe not responded to and having to reissue it. So if we're able to take the learning from that and find ways of applying it more broadly, but there are pros and cons with the different options for doing that. But that's the sort of thing we're trying to work through at the moment.
Is that what you meant by looking at the front end of the process?
Yeah, an issue that was raised with us in discussion with Criminal Justice Inspection was whether we should be trying to move more towards the use of charge, because at the moment it's only about a third of cases proceeding by way of charge, 2/3 by summons, and summons is proven to be a more inefficient process in terms of getting cases through the process. But we want to proceed quite cautiously on that, because as soon as you move into the realm of charge, you raise the prospect of the young person either being out on bail, during which breach of bail could recriminalise them, or having to be remanded in custody. And obviously we're very keen to avoid bringing young people into custody unless absolutely necessary, particularly when we've made good progress over the last few years in reducing the number of young people who have been remanded in custody. But for certain types of offenders, we think it could be justified, but that would be quite a development in what we're currently doing, which is why we wanted to take the views of stakeholders. And if we wanted to be a lot more proactive in charge, I think we would have to do some further consultation, maybe pilot that. But those are the sorts of issues that we're trying to progress at the moment.
And just one final point, what has been the reduction of young people in custody? Have you a percentage of it?
I don't have the figures to hand, but I think the last figure I heard was just about 22 young people currently in custody. I would have to check that for you, but I know that there's been quite a marked decrease over the last number of years.
Thank you. Tom?
Chair, thanks. Thank you again. The department proposal, the full rollout, I'm just looking at your focus for the next 6 months, and it says the full rollout of the Victims and Witness Care Unit.
Yes.
What do you envisage by that when you say the full rollout? Is that something will be available to every victim and witness then?
Yes, the intention is, and that's sort of dipping into the next
We're going
section.
to do it in two separate
Okay,
bits.
that's
We're
all
going to do that, if that's okay.
All right,
Okay.
I'll come to my other point then around the time limits, and obviously that's a big issue, whereby the department is not proposing to implement what the Youth Justice Review report said.
Yeah.
And I know every time we come back here there's questions around it, and we never seem to make any progress. And I'm just wondering, are you totally fixated on not progressing the Youth Justice Review recommendation?
I suppose for a lot of stakeholders, the Youth Justice Review was their starting point, and because there was a recommendation in that, they were sort of measuring us against how well our proposals would fit with that. But actually, we're responding to a number of independent reports here, including earlier reports from Criminal Justice Inspection. This is an issue that's been raised a number of times in the past as well. I suppose what we've sought to do through the consultation, and we went through this in an awful lot of detail in the consultation document, trying to set out the reason why we thought there might be difficulties with starting at the point of arrest, and we've explained that at this table, as you've noted a number of times before. And we've also sought to set out in a lot of detail what are the other initiatives to support improvements in case processing time from end to end, basically the whole way through the process, so that it's not just STLs aren't the only show in town. Now, despite that, and despite the extensive pre-consultation we've done and the discussions we've had with stakeholders during the consultation period, there does still seem to be a strong view among a number of organisations, principally within the youth lobby, but it tends to be throughout the voluntary sector particularly, that we should have an earlier start point. I think the key issue for us is we want to try and avoid any perverse incentives arising as a result of whatever option we choose. And a number of people have put forward this idea of starting at the point of accused informed, but our difficulty with that is that's not a statutorily defined point, it's an administrative point. So as things stand, we wouldn't be able to implement that just in the way that people are suggesting. I think obviously, given that there is a body of concern there, that's not something we can easily set aside. We're not just sort of going to ignore that. So we need to look at what the options are. One option is that we revisit the start point, and we'll have to put a range of options to the Minister. But there may be other options that we could consider, which would be sort of looking at what more we could do procedurally at the front end that might help to allay those concerns, and maybe have some further discussions with stakeholders about whether that would go some way to meeting their concerns.
But at this stage you're opposed to the principle of implementing the Youth Justice Review recommendation?
Well, we've been very open about the fact that we think the appropriate start point is charge and complaint, and we've set out our reasons for that.
The answer is yes.
Essentially, yes.
Okay, thanks, Chair. Thank you.
Okay, Alban?
Thank you, Chair. I mean, your target is 120 days, is that correct? Or
That was the timescale we proposed. Yeah.
Yeah, and I think the argument coming from NEACRO and from other groups is, in support, is really it's not a very stretching time period. How would you respond to that?
I suppose we would say that the view we get from the statutory agencies is that that should be quite challenging. If you look at the fact that at the moment, I think our latest figure for charge cases, youth course, about 109 days. And that's on average, so there'll be cases that take longer than that at the moment on the basis of charge. For summons cases, it's 217. At the time we were looking at 120, it was over 240 days, so it was going to be about half of that. So in relation to summons cases, I would say that that is quite
just
challenging.
Dealing with the charge cases, though, I mean, you're talking of an average of about over 100 days, not put your statutory time limits at 120, so
Yeah.
it doesn't seem to me to be that demanding a statutory time limit in the charge cases anyway.
Yeah, well, one option is that you set a shorter timescale for charge cases than for summons, but then that creates a perverse incentive that you might want to proceed by the way of summons because it gives you more time. So that's what we've had to weigh in the balance as well.
Would it not be a way of dealing with the situation? I mean, could you not start with charged cases and leave summons cases? I don't know if you could or not.
You could, legislatively, yeah, you can implement in a phased way. I suppose the issue is partially, as you've already sort of identified, the problem in our system isn't really charge cases, which happen relatively quickly, and are a relatively small number of cases going through the system. So if we want to tackle where the greater problem is, then we need to tackle summons cases. So we wouldn't, in a sense, it would be easier for us to deal with charge cases, but we wouldn't really be tackling where the problems in youth cases lie. So we might make some improvements, and in those cases that would be good, but we wouldn't be tackling where the real problems are.
But the other point though is if on average your summons cases are around about 240 or thereabouts, 120, although it's a massive improvement, in the summons cases, I mean, it's just far too lax really in terms of the length of time taken to complete cases. I mean, that really is a serious problem, I think.
And that's really why summons is the focus of what we're doing at the minute, is because the time taken for summons cases is massively too long, and for young people in particular, who are trying to move on with their lives, maybe the fact that a court case comes back 2/3 of a year later after they've maybe whatever it is they've done and they think it's maybe settled, and then it sort of comes back to them. So we've heard stories about people who've left school, got a job, and then proceedings sort of come in and
disrupt the whole thing.
Yeah, absolutely. So I mean, and that's really why I think summons is the focus of what we're trying to do. I mean, I suppose the other thing about statutory time limits is they're not really meant to set out your average performance. It's meant to be a sort of statutory statement of the absolute maximum time that the system will tolerate for a case to happen. So in a similar sort of way to statute bar cases, which say you have a total of 6 months to initiate proceedings. Now, you should be aiming to do that more quickly. So what with statutory time limits, we're not trying to say to the agencies, right, you can relax for 120 days. It's sort of 120 days is the absolute maximum they should be taking. And if you can do it more quickly, then you should. And that's where the reforms such as statutory case management come in, because they, at the other end of case initiation, say, here are the things that the judge will expect you to have resolved by the time you bring a case to court. So things like agreeing witnesses, agreeing what evidence can just be agreed on the papers, that kind of thing. So even before cases in front of a judge, we're looking to the PPS and to the defence to manage cases more effective than they are at the minute as well.
Is there any way of making a statutory point of beginning in a summons case? I know you've talked more about it being an administrative action, but is there any way of constructing a statutory beginning to summons case?
I think that's the tricky thing. I mean, the statutory start, I guess, is at the minute where the complaint is laid. So I suppose what you're talking about is making the point where the police say, we intend to write to the PPS about you, a statutory event, which, I mean, technically, yes, we could do, but the definitional problems are what I think would cause us difficulties there, because you would have to be able to define precisely the circumstances which oblige police to say to someone, we're bringing proceedings against you. That probably would require the police to make a determination about the state of readiness of the case. So that brings into it a kind of unavoidable subjectivity. What we have at the minute is a statute bar, which is unavoidable. If you want to bring proceedings, it has to be done within 6 months. And then once they're brought, the second time limit kicks in, which is also unavoidable. You bring charges against someone, the second clock starts ticking. If we were to sort of bring that forward to the point at which the police decide the case is sort of solid enough to proceed, all that may mean is that police officers become very cautious about when they decide the case is ready, and that point isn't massively different from the point at which the charge is laid. In Scotland, what they do is, because they have time limits, and their system is very different to ours, but in Scotland, before a time limit is initiated, the police have to approach the fiscal, who then says, yes, you're authorised to investigate this case and this is how long you've got. Now that's a very, very different system to ours, but what it means is there's some kind of independent oversight of the way time limits are managed. So that, I mean, and that's really the resistance we have to moving beyond the point of charge, because it's where you have operational independence, where you have operational decision making. It's very difficult to define in legislation how that should be exercised for every case.
And if we just simply made that a statutory point, there's a risk that in practice it would occur at a later stage, because that starts your clock ticking. And one of the issues that was coming through in some of the consultation responses was that young people are saying there's a problem with how they're communicated with in the early stages, and I think that's something we need to address as well. If there's reluctance of the system to engage formally with them until a later point because it's going to kickstart a time limit, that could actually work against providing better information and helping the young person to make better decisions about their options as well. So I think we'll have to look at all of this in the mix, and we'll have to look sort of holistically at it, and everything has to come back to best interests of the child, and we have to be wary that in doing one thing we don't create a problem elsewhere. So I think there's probably a need for some further discussion with stakeholders, which will take a bit more time, but I would rather do that than just sort of plough ahead with something with a body of concern about how we're doing this, and see if there's some way in which we can reach some sort of consensus around this. But as I say, we're going to have to brief the Minister. We'll put all of the available options to him. The one you mentioned about starting with charge cases only could be an option, and we could look at the pros and cons of that. But until he's reached a view on that, I don't think we can really say today where we might go with this. I think there's some further work to be done there.
Thank you very much, Chair.
Okay, just on that particular point, where you have the sort of prison review and the youth justice review, and they come to similar conclusions around statutory time limits, and then you have the papers today from the ACRO victim support and include youth, more or less saying that that's the best way forward, but the department seems to be at odds with that. Now, what engagement do you have with the two, particularly the two review groups, and then obviously the community and voluntary sector in relation to explaining your position? Or is it a matter like we just think you're wrong and we're going to go about it in a particular way?
In relation to the Youth Justice Review, the progress against that's now been monitored by Criminal Justice Inspection, who we have a sort of a long-standing relationship with anyway, and a lot of what we've been doing through the Speeding Up Justice programme has been informed by their recommendations, and actually their own report in relation to statutory time limits didn't specify arrest as the appropriate point. They were leaving that as a matter for the department. The Prisons Reform Trust, the review, that has oversight arrangements in place as well, which we feed into, so we report on what we're doing there. But it's difficult in some ways that we're reporting against a series of slightly different recommendations. So what we have to go back to is what the Minister is committed to, which is basically committed to the introduction of time limits within the mandate of this Assembly for youth cases, and then to review whether and how we might get into the adult sphere at a future point. So that's really our starting point, is what he had concluded on foot of Criminal Justice Inspection reports. The recommendations from those other reports kind of came along as we were working our way through this, and as we were already having the discussions at Criminal Justice Board level about how we might take this forward.
Okay, thank you. Rosalind?
Thanks very much for the presentation. In terms of the overall time limits, do you feel it's been suggested that it would be better if this were broken down and that each stage would have an individual time limit, because there's different agencies involved, and you can see how if one agency maybe takes too much time, it might impact on another agency. What do you think? Do you think it should happen like that?
We did look at that at an earlier stage when we were deciding whether there should be one time limit, or there's lots of different ways in which you can use time limits. We could see pros and cons with that, and I suppose the con was, if the police's time limit was about to be breached, they would just fire the case on when it's not quite ready to the Public Prosecution Service, and then they would have to take time out of their time limit to go back with requests for further information. So again, it's all down to anticipating behaviours. what would actually happen in practice if you did in a particular way. I think we did give the options to the Criminal Justice Board, and I think they favoured a single time limit as something that would be a bit less bureaucratic and easier to manage, because what we don't want is to create a mini industry within the justice system and generate confusion about what point we're at or what's meant to be happening. So we felt initially, at least, that was probably the best way forward. But it is an issue that we have looked at.
Right. And if it were to be the case that it looked like some agencies were taking too long, would you look then at that?
We could look at that. I think now we've got the Causeway reporting, it allows us to look at what's happening underneath the time limit, and you know, if we're having difficulty in meeting time limits or we're coming in very tight, we can look to see why that's happening and where the problems are occurring. We've got more information now that we can use, and we can start to break it down a bit more than we did previously.
Right, okay. And there's also been a suggestion that within the proposal there should be maybe some looking at a mechanism for how it's impacting on the people involved, you know, like the victims and the offender and their families, so that they're not treated like observers in the process, that they're actually included, they understand the process, because sometimes people don't understand what's happening. It seems to go on, while it's about them, it seems to go on past them as though they were merely observers. Should there be, do you think there is a place for a mechanism to ensure that people do understand what's happening?
I think that's a very good suggestion. Certainly on our victim strand of work, one of the things we're looking at is better information communication and helping to demystify the process for people and giving them more real-time information about what's happening in the case. So certainly that's something I'd be happy to pick up. And as you say, it's not just the victims or witnesses, it's sometimes on the offender side or accused as well. Very often they feel as if they're in the dark about what's happening and not knowing what's going on. So I think that's a very fair observation, something we're happy to take away and look at.
And would you consider like having support in place, because people can be traumatised at different stages along the way, so that should, you know, depending on what might arise, would that be something you consider?
I think certainly in relation to victims and witnesses,
extensive support there in terms of
there's been some improvements, and we'll be talking shortly about the rollout of the Victim Witness Care Unit, and the fact that now includes an initial needs assessment and reviews of needs as a victim or witness is moving through the process. So there's a mechanism already in there for that, but I suppose one of the things we'll have to be alive to is, you know, if and when we introduce a time limit, a statutory time limit, whether that's having an additional impact on victims and witnesses that wasn't there before.
Okay, thanks very much.
Very much. Nobody else has indicated, so we'll move straight now into sort of the victim sex aspects. Okay.
Okay, well, I think we're almost naturally moving into victims and witnesses already. And on that, we've moved on a bit since we submitted the papers, and at this stage we're anticipating that we're almost halfway through the first year of our first 2-year action plan, that by the end of this month we should have achieved 18 of the 30 actions that we'd set out. One area where it looks like there might be a little bit of slippage is in relation to finalising new guidance on supporting intimidated witnesses. We'd hope to have that completed by the end of March. We've had it in draft since early December, but it's just taken a bit longer than anticipated to get final sign-off from all of the agencies. Some have responded, but we still want to check that the detail of that is right before we publish it. I don't think there are any significant issues with it. It's just people getting the time to give that their attention. But we're aiming to have that finalised during the first quarter of the new business year. Other than that, the remainder of the targets appear to us to be on target, and we'll continue to monitor those closely. In terms of the key achievements so far this year, I think further rollout of the Victim Witness Care Unit model has been significant. I think the intention is for that to be completely rolled out by the end of April, so we're very close to that having full coverage across all areas in Northern Ireland. We've now got in place our new arrangements for victim personal statements, which we briefed the committee on towards the end of last year. We've extended remote live link facilities, and we're well underway with the pilot registered intermediary schemes. As of yesterday, actually, we had our 100th request for a registered intermediary for cases involving vulnerable persons, including young children, so that's working well. In addition to that, we've just published a new autism guide for criminal justice professionals, which wasn't part of this action plan. It was actually in response to a new cross-departmental autism strategy, but I mention it just because it's another useful tool for us in terms of supporting vulnerable victims and witnesses, as well as vulnerable suspects and defendants. Looking ahead, we're planning to come back to you in the near future with a draft of the Victim Charter, with a view to launching a consultation on that before the summer. We discussed the Charter at a meeting of the Victims Champions Forum earlier this week, and we've asked the agencies to plan for its introduction initially on a non-statutory basis, because we thought rather than waiting for the Faster Fair Justice Bill to get through, because we're coming along behind the Legal Aid Bill, we would go ahead and publish that on a non-statutory basis by around the end of the calendar year, and then put it on a statutory footing the following year. That would allow us as well to meet the deadline for transposing the EU directive on establishing minimum standards on the rights, support and protection of victims of crime. So our next report will provide a further update on the Charter, and it's also likely to cover the work underway to reduce waiting times at court, to improve information sharing, and the outcome of the allocation of this year's Victims of Crime Fund. As well as by that stage we should also have the latest results from the Northern Ireland Victim and Witness Survey and some other research that we have underway. So we're happy to take any questions on the
thank you very much for that. If I could just begin, in terms of, and you've outlined some of the, what you described as key achievements. If someone was observing this from this time 18 months ago, would you say the changes are noticeable, and people would say that there has been a step change in the approach to this particular issue?
We've had some really good feedback from some of the voluntaries, Victim Support, NSPCC and Nexus, for instance, on the difference that the Victim Witness Care Unit is making. They've noticed an appreciable difference in how victims are being treated with that new service. I would say as well, the registered intermediaries, it's something we haven't had before, so it's completely new, and the feedback on that has been very positive to date. Now we'll be formally evaluating that at the end of the pilot, which runs to the end of November. But the indications so far are very good, and the feedback from victims and witnesses in particular has been that they've felt better supported through the process to date. Even in cases where there hasn't been disclosure, or it maybe hasn't got to court, just the fact that an extra effort was made to allow more vulnerable people to try to provide evidence has been very much appreciated. So I think those are a couple where we've had sort of direct feedback already, but I think part of what we need to do and to continue to do is to sort of more formally evaluate these service changes. And I know that the Victim and Care Unit Project Board has been looking at building in evaluations as we go. There wasn't sort of a small-scale evaluation before we started rollout after the pilot, just to identify any sort of immediate issues that needed to be taken into account in the design. But there'll need to be ongoing review of what's happening there, just to make sure that it's delivering the service that's intended. Anything else, Veronica?
I think for me, the Victim and Witness Care Unit would be the big one. And I suppose in terms of the registered intermediary scheme, as a result of that, we're seeing disclosure from children as young as 2 or 3. We've about a third of the cases that are coming through at the moment are involving young children. In terms of the offences and the vulnerabilities that involves, it's largely those with learning disabilities or victims with a very young age. And in terms of the offences, largely sexual offences that we're seeing coming through, and assault. So I think the big difference for it really is cases coming through that previously the police would just have had to say we can't take this forward due to either the vulnerabilities or difficulties that individual has, and I think that's making a material difference in terms of ensuring that justice is provided to victims and witnesses as they go through the system. Yeah, I would see those as the 2 big things.
Okay, I mean, in terms, I think you talked about a feedback. Is that recorded? Is there some sort of recording process where, if you're speaking to the particular agencies, that's recorded so it can be tracked for the future?
In
Yeah.
terms of the registered intermediary scheme, we're taking feedback from the Police Public Prosecution Service, council that are involved in the cases, and also the judiciary in relation to that. So we'll be looking at kind of the process for each of those cases, the way in which they've worked, what's deemed to be the benefits of them, any difficulties that have been encountered, and trying to take that into account in terms of taking the scheme forward.
Yeah, and putting that into the public domain, is there any strategy to bring that to the public domain to some sort of reporting mechanism, or is that
Well, we'll be
just...
doing an evaluation report at the end of the pilot, and I would imagine we'd be making that available.
Thank you. Tom, you were sort of on a question. So
Chair,
just-
that's right.
Yeah.
I was obviously trying to establish the six-month focus, and in particular the victim programme, and I'm just wondering how you seen that. I'm sorry, I've lost the place here now. So, I'm just wondering how you seen that rolled out, and if it would apply to all victims and witnesses throughout Northern Ireland.
I think as of the end of April, it will be applying to all victims and witnesses. I think that's the intention. There are now 2 offices operational. It started with an office in Belfast. There's now an office open in Foyle, which is picking up a number of other areas. And I think that, as far as we're aware, is on target. So they've been making good progress with that.
Although one in Belfast and one in Foyle will not just cover all of the Northern Ireland.
Well, most of the contact with victims is by way of telephone. In the past, it would have been by letter, so it's a step in the right direction, I think. There can be a facility for face-to-face contact in certain cases, but that wouldn't be the norm. It would mostly be telephone contact. But it was felt that the 2-centre model would be the best way of delivering that.
How the assessments that were carried out, or the audits with victims and witnesses, how did they feel about it mainly being contact by telephone as opposed to direct contact?
I suppose the feedback's been mainly from organisations representing victims, because they can compare the before and after, and I suppose the main difference they see is that instead of quite legalistic letters going out, it's actually a person, and it's a name contact, and it's someone that the victim can contact at any time if they want an update in the case. Plus there'll be regular contact from that individual once there's anything to let them know about. So I think the requests from victims for direct contact would tend to be fairly low. There are certain circumstances in which they can seek a meeting with the prosecution service, for instance. But for the vast majority of victims, I think they're happy enough with just getting the information. And I don't think the fact that it's not been delivered face-to-face is necessarily proven to be an issue.
And is that information proactive? In other words, you don't necessarily wait for those people running it, don't necessarily wait until the victim or witness phones them up. They actually try to be proactive and say, there's been a development. And
if there's been a development in the case, then they will be proactive and let the victim know about that. But sometimes, there can be periods of time where not much happens, and the victim can contact them in the interim just to check if there's anything going on. I know that the PPS are also looking at the development of a victim information portal where victims can go online just to see if there's been any developments in their case, and that's something they're working on at the moment. It's one of the measures we're intending to support through the Victim of Crime Fund.
okay, thank you, Chair.
Okay. There's nobody else that's on the... Roseanne, sorry?
Just a brief question for Margaret. Just in relation to, we went on a visit to the centre in Antrim for victims of sexual crimes. I'm just wondering how that service has been progressing, because it was only opened when we went to visit it. And what would the update be on that?
Although, well, the work around victims of sexual domestic violence are been led by colleagues in the Community Safety Unit through the Domestic Sexual Violence Strategy. So I'm afraid I mightn't be entirely up to speed with that, but as far as I understand, progress in that has been good.
In terms of the work involved in that.
Yeah, we've been keeping in contact with colleagues just with a view to seeing whether in the coming financial year we might be able to help through the Victim of Crime Fund with the development of the role of independent sexual and domestic violence advisors, which I think is progressing. So that will be another enhancement to the service. But certainly we can find out for you if there have been any other developments and let you know.
I suppose in terms of the crime fund, we're hopefully looking at in the region of, I think it's just short of £100,000 that would be given money towards both the sexual advisors and the domestic violence advisors in terms of training of those staff and rollout of the pilot scheme. So we're hoping to be able to give a chunk of money towards those measures, which would obviously have benefits in terms of that SARC centre.
Okay, thank you.
Okay, no other questions, so can I thank all for you for being and giving us the evidence this afternoon. Thank you very much. Thank you. Members, with your indulgence, we had an item under Chair's business earlier on, and Mr Anderson referred to the Dairy Committee this morning and something which you were on. So, Patsy, I'll invite you on now just for that information.
Thanks very much, Chair. At the Dairy Committee this morning, it was raised the whole question of Desert Crate, the Community Safety College, and the degree of uncertainty that has arisen around that project and the consortium, where it's been reported that the consortium is pulling out from the bid. Very clearly, there's a big regional economic interest in that, and many of us have, indeed myself, I would have to declare a slight interest in the local constituency as well as advancing policing training. So what the EDI Committee unanimously agreed this morning was to request yourselves, given the import of the economic consequences and the import of the Justice being the host department, to seek an urgent joint committee meeting with the appropriate authorities, whether that's the project board or whoever it may be deemed necessary, to get an urgent update on this particular, what seems to be a pretty bad news story that's breaking, that would have serious ramifications and consequences, because it was been held up as almost the tipping point for the local economy, where we'd see things start to change, where we would see investment of a very significant scale, and where we'd see the domino effect into the local community in the Mid-Ulster area, but also regionally too. So that was the agreement of the EDI Committee this morning, to forward or to approach this committee and seek an urgent joint meeting with the respective people responsible for the project.
Okay, in your absence earlier, we had agreed that we would seek a meeting, so I'm just asking numbers. I'm conscious that Tom's not out, but I mean, Mr Anderson's here, Sydney's here on behalf of the DUP, but the proposal would be that we'd have a joint meeting with the Justice and the Dairy Committee together, and possibly if that was possible, the proposal is we would try and do it over a lunchtime, rather than try and coordinate it around the two committees. So, I mean, that has to be a formal proposal, so I'm just going to ask members to agree that this matter be disposed of by the two committees sitting concurrently. The purpose is to take oral evidence on the current position in relation to the Desert Crete Training College. So we're happy enough of that? Okay.
Thank you.
Right, Chair, could I just clarify, the Justice Committee earlier had asked to see whether we could get that arranged for next Thursday. So if you're content, then we'll liaise with the clerk and the chair.
Yeah, you could. The only thing is that I think maybe Thursday AM we're away out of the building on a committee visit to Dungannon, but if it can be arranged this afternoon, that'd be great.
Maybe if it was possible, could we ask for a Wednesday, because I think we're
going to be here anyway.
We're all recalled on Wednesday,
Tuesday,
and there will be
Thursday.
gaps throughout the day.
Might be able to do it on Wednesday.
Right? So would people prefer Wednesdays because we're all going to be here rather than try and coordinate it on the Thursday?
Wednesday, Thursday. It's that important. We need to be. No.
Wednesday, you should all be
Should be
here.
here, and we'll be
On Wednesday.
okay. So whatever. I mean, it might be down to project board, but we'll certainly we'll agree in principle that we go ahead together as a joint.
Thanks, Chair.
Okay, thank you. Agenda item number 7. We're going to go through a number of statutory rules. So, in relation to statutory rule 214/47, the explosives, hazard, information and packaging for supply amendment regulations. Can I refer members to page 153 to 164 of your meeting folder? Tom, just before we proceed, the Dairy Committee this morning made a proposal that we would do a joint committee meeting in relation to being briefed by the project board of the Desert Crete. So the committee has agreed to do that. We'll do it as a joint meeting and possibly seek it to do it on Wednesday or Thursday of next week, just subject to whatever arrangements can be made. So we just done that in your absence.
Chair, I have no difficulty with that. Jim Wells is out now, but maybe the health committee will want to have an input. But that's up to them.
When they hear we're doing that, they
totally accept, support what you're doing. Sure, yeah.
We nearly do it in the chamber then. I bet many had it.
That's right.
Anyway, back to the statutory rule. At the meeting on the 6th of February, the committee considered and agreed that it was content with the proposal from the department to make a statutory rule to comply with EU regulation number 649/200 or 2012 concerning the export and import of hazardous chemicals, which will apply from March 1st, 2014. The statutory rule was laid by the department on the 27th of February 2014 and is subject to the negative resolution procedure. There have been no changes to the policy content since the SL1 was submitted in committee. At a previous statutory rule, SR 2014/26, laid on the 7th of February 2014, will be revoked by this new statutory rule to enable technical amendments to address drafting defects highlighted by the Examiner of Statutory Rules in his report on the 21st of February to be made. The revocation of the previous rule and the laying of a new rule to make necessary amendments have resulted in a breach of the 21-day rule. The Examiner of Statutory Rules has, however, found the breach fully excusable in the circumstances and has confirmed that he has no further issues to raise with regard to the technical aspects of the rule. So I'm asking members if we are content with the statutory rule.
Yep.
I'm now going to put the question that the Committee for Justice considered statutory rule 2014 number 47, the Explosive Hazard Information and Packaging for Supply Amendment number 2 regulations in brackets Northern Ireland 2014, and there's no objection to the rule. Agreed. There are now 3 statutory rules, and they're on pages 166 to 207, and I'm going to take the 3 rules together. Can I remind members that at our meeting on the 9th of January, the Committee for Justice considered and agreed that it was content with the proposals by the Department to make 3 statutory rules required to introduce a filtering scheme for Access NI disclosures to comply with the recent judgments of the European Court of Human Rights and the Court of Appeal in England and Wales. The statutory rules have been laid collectively, and the purpose and the proposed operational date for all 3 is the 14th of April 2014. One rule is subject to the affirmative resolution procedure and the other 2 subject to the negative resolution procedure. Draft statutory rule, the Police Act 1997 in brackets Criminal Record Certificates Amendment Order. The statutory rule, the Police Act 1997 Criminal Record Certificates Relevant Matters Amendment Order, which has been laid in draft form, will be subject to affirmative resolution procedure, will amend the definition that sets out what is to be disclosed by Access NI in response to an application for a criminal record certificate or an enhanced record certificate. It provides for the introduction of a scheme to filter out certain old and minor convictions and disposals from disclosure, and includes a list of legislation which specifies offences that will never be filtered. There has been a change to the policy content since statutory SL1 was submitted to the committee. The draft statutory rule now provides an informed warning given to a person, irrespective of age, is a current informed warning if the date on which it was given fell within 1 year of the period ending with the day which the certificate is issued. The draft order sets out in SL1 only include a provision for informed warnings given to those aged 18 and under. The Minister of Justice plans to have this draft statutory rule debated in the plenary during the week commencing the 24th or the 31st of March. The statutory rule SR 2014/27 which was made by the Department of Justice on the 5th of February 2014 and is subject to negative resolution procedure, will amend the Rehabilitation of Offenders in brackets Exception Order 1979 by introducing provisions so that some old and minor spent convictions will no longer have to be disclosed and cannot be taken into account in employment decisions in certain circumstances. There's been a change to the policy's content since SL1 was submitted to the committee. This rule now includes an additional amendment to remove non-recordable service offences from the ambit of exceptions legislation in the jurisdiction. There are minor offences for conduct that have no criminal law equivalent in the civilian field, such as absent without leave, and this change is made as an extension of the filtering system so that they can be considered spent once a relevant rehabilitation period has been served, need not to be declared thereafter, and will not be disclosed as part of any future record check. The statutory rule SR 2014/28, which was made by the Department on the 5th of February 2014 and is subject to the negative resolution procedure, will enable Access NI to disclose in the course of issuing standard and enhanced record certificates information in relation to cautions, diversionary youth conferences and informed warrants held on the Causeway Criminal History Database. There have been no changes to the policy content since the SL1 was submitted to the committee. Are members content with the statutory rules?
Content.
If the committee is content, I will now put the questions. If the Committee for Justice considered draft statutory rule, the Police Act 1997 Criminal Record Certificates, Relevant Matters Amendment Order 2014, and recommends that it be affirmed by the Assembly. Are all members content? That the Committee for Justice considered Statutory Rule 2014 number 27, the Rehabilitation of Offenders Exceptions Amendment Order 2014, and has no objection to the rule. Agreed. That the Committee for Justice considered Statutory Rule 2014 number 28, the Police Act, inverted commas, criminal, or brackets, criminal record, brackets, amendment regulations, NI 2014, and there's no objections to the rule.
Great.
Just to advise members that the Chairman will reflect the views of the committee in the Assembly debate on the motion to affirm the draft statutory rule. Okay. So I will now move on to item number 11, regulations allowing closure of settled tax credits appeals in England, Wales and Scotland. I refer members to pages 209 and 210 of the meeting folder. The Minister has written advising that the committee of his intention to give the Department consent to regulations made by Revenue and Customs which will allow it to close down settled tax credit appeals in England, Scotland and Wales. Prior to 2009, a power to close down tax credit appeals existed. Elapsed unintentionally in England, Wales and Scotland in 2009. While the power remains in existence here and the draft regulations do not therefore extend to here because of the way the power to make a regulation is framed, the Department's consent is required before they can be made. We have to note the intention of the Minister to give consent to these regulations made by Revenue and Customs, which will allow it to close down settled tax credit appeals in England, Wales and Scotland. Okay, everybody happy with that? We're now going to move on to correspondence, and I have only two items, and that's item number 1 at page 214 of the meeting folder. There's a copy of a letter from the Department to the Department of Environment in relation to Local Government Bill providing information on areas of policy responsibility that are specified as a duty or responsibility of a council, and whether a discharge of the function could be the responsibility of the council's executive or should be the responsibility of the full council. So I'd just like to take members' views on that, and particularly relating to the establishment and appointments to the policing and community safety partnerships should be the responsibility of the council as a whole rather than a limited number of members, and has indicated this in the letter. We'll just ask members to note that. At item number 2 is on page 200. Oh, sorry, my apologies. Can we seek agreement that we send a copy of this to the Committee for the Environment? The correspondence from the Department in relation to the Statistics and Research Agency report on sickness absent for DOJ staff in the financial year 2012-2013. The department has the highest levels of sick absence across the civil service, with 12.9 days, and did not meet the target set for itself of 10.3 days. The lost production, to note, was estimated around at 6.3 million. The department has indicated that a number of initiatives are in place aimed at ensuring that sickness is robustly managed and levels are reduced. The committee has requested further information from the department on the relevant aspects of the Audit Office report on sick absence in the public sector, and we may wish to return to this matter when more information is available. Can I ask members if any are items they wish to raise in relation to correspondence? And can I seek members' approval to action the correspondence as outlined in the meeting pack?
Great.
Item 13 was Chairman's business. We've already covered that. So we're going on now to item 14, any other business?
Yep.
Can I just say item number 15 is the date, time and place of next meeting, next Thursday, 20th of March at 2 p.m. in room 30, Parliament Buildings, unless the other meeting in relation to Desert Creek will be informed. Thank you very much.